Hey everybody, welcome to the Little Law School today. I want to talk about the First Amendment and these protests on campus. There are questions around what is appropriate and inappropriate under the First Amendment in terms of breaking up encampments and stopping student speech. The First Amendment is only going to apply to public colleges and universities, any state university or municipal city college. It does not bind private universities. There are some states like California that have statutes that implement some of the First Amendment protections, but for a place like Columbia, they could adopt for themselves the First Amendment law as their policy, which some universities, private universities have done, but they're not bound by it. There's public pressure too to do that because I think people assume universities are going to comply with First Amendment protections. Now, First Amendment protections include freedom of speech and freedom of assembly. So you're allowed to be in public spaces in groups, and there are private spaces that are sort of public, quasi-public under the law. So like a campus lawn, even if it's a private space, could trigger some First Amendment protections to some degree. So what can universities do, or the government do? There can be what are called reasonable time, place, and manner restrictions on speech. So they can decide what hours you can protest, certain places, and other kinds of reasonable restrictions, but they cannot make any distinction based on content. So they couldn't, for example, clamp down on pro-Palestinian speech and not on pro-Israeli speech or vice versa in this current context. And if they do impose those kind of restrictions, it has to be narrowly tailored and also allow an alternative mechanism to speak. Now, what about the police? When it crosses into speech that is making it hard for schools to actually perform their educational function, then that First Amendment protection starts to subside. So if protesters started blocking the doors to getting into class, or screaming so loud at professors that they could not actually be heard by the students, or of course if they start inciting violence or engaging in violence, you wouldn't be able to touch a professor or touch another student. But this is really important. The fact that speech is uncomfortable for people, the fact that it's even offensive, that is protected. There is no restrictions under the First Amendment on speech that might be hard for people to hear and distasteful or even make people upset. That is protected. So sometimes I think in this discussion that gets a little bit lost. Students don't have protections from hearing speech that other students make that is uncomfortable. Now, there is such a thing as hate speech. For example, certain groups are protected. Defamation, of course, is illegal. You can't lie in a way that ruins someone's reputation. You cannot possess child sex abuse imagery. That speech, there are lines that you definitely can't cross. But in general, the idea behind protests is maybe to make people uncomfortable to the point where they would initiate some change.
Genocide! Jerry, I'm below, can't you see? Jerry, I'm below, can't you see? You are supporting genocide! You're supporting genocide!
So the discomfort itself is not something that the government can interfere with. Now, what if the police are called? If the police are called and they give an order to disperse and they give time for the protesters or those in an encampment to leave, then that's legal. They cannot tell people to leave and start arresting them physically in the moment without offering enough time for them to comply with the order. So there are lots of nuances. I hope that helps. I'm Kim Whaley. This is the Little Law School. Have a great day.